Down at the bottom it said calculate. So 3 hours and 24 minutes. Yeah. Good morning, members. Let's go ahead and get started. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
10, and we have a quorum.
All right, we've got a quorum. I'm going to take a little bit of personal privilege and say thank you to all the administrative assistants out there. Today is Administrative Assistance Day, and we could not do what we do without y'all. And a personal thank you to Holly. She puts up with my inadequacies and helps me overcome those from time to time. So thank you very much. All right, Holly, if you call the first bill on the agenda.
SB 158 by Senator Elliott.
Senator Elliott.
Thank you, Mr. Chairman. Members, SB 158 deals with involuntary commitments and notification that an individual has received an order of involuntary commitment to ALEA, and that for ALEA to use an existing database to make sure that that is available to police officers during a traffic stop.
Senator Smithman.
I support the bill, and I'm gonna vote for the bill. But I do want us, as we move forward with our budget, to realize that it may need to be a little bit, not just for this alone, but we may need to get the judges' budgets a little better, because we're going to require more work. And I can just tell you, I'm not the only one who can tell anybody this, but trial going on, them people in the courtroom. When the judge makes an order, they going out there to type these orders on the spot. I think you get orders back probably the same day now. And so we putting another work requirement on them, which I understand, but they may need additionally some help. It just depends on the volume, if there is an increased volume of these people. So I want us to think about that as we move forward with, we're not talking about a lot of money, but we're just talking about, either give them some flexibility. Some of these folks may have some money, some fees or something, but we've got to loosen up something if we're going to start throwing some more work, which I agree with you. You're not talked about this.
Yes, sir.
We spent about 30 minutes to talk about this, so I agree 100% with what you're doing. But I just wanted to say that to everyone as we move forward in that process. I'm not on general fund. That's why I'm talking to you all. So
very good.
Thank you for your comments, Senator Gavan.
Yeah, thank you. So I would like to work with you, not necessarily work with you, but have an understanding offline about the exactly words, the way they were tweaked, just to have a better understanding of that. But thank you.
Very good.
We got a motion for favorable. Do I have a second? Senator Coleman Madison. Senator Elliott.
If you don't mind real quick, I've got the police chief from Bay Minette here, and I would like, if we can have 60 seconds or so, we don't have a public hearing scheduled for this, but I'd like for him to come up and tell us how this might be beneficial in the field. If you mind, he's made a trip up here, and we can just have 60 seconds real quick.
Be glad to. Chief, you want to come on up? If you would introduce yourself to the committee.
My name is Al Talbert. I'm the police chief for the city of Bay Minette. And just want to thank all of you for allowing me to be here today, and thank Senator Chris Elliott for sponsoring and drafting this bill. On August the 20th, 2022, I had a police officer make a traffic stop on a vehicle for relatively minor traffic violation, and it turned into an officer-involved shooting, and ultimately the suspect lost his life. This individual had been involuntarily committed several times and had about a 10-year history of mental illness. And there's no doubt in my mind, had this flag, been entered into the Let's database, I believe this officer would have treated this situation differently and the outcome would have been different. So our push behind it is it would be a huge officer safety benefit to the police officers, but even more importantly, it would be a huge safety benefit to the public and public safety. And this would be most all law enforcement agencies in the state now are using the Let's tactical system, whether it be a patrol officer or investigators or whomever. So when it's just not benefiting the patrol officers out on the street answering the calls. It's also benefiting the investigators who's working the crimes behind the scenes, so to speak. But again, I just wanted to say that a little bit. I know I probably took my 60 seconds more, but you're right. Appreciate all the administrators out there. They do make us all look good. And thank you for what you do. And thank all of you for allowing us to be here and speak about this. Appreciate it. Thank you, Chris.
Thank you, Chief. Senator Coleman Madison.
Thank you, Mr. Chairman. Sir, I want to thank you for coming as well. In reading this bill, I never really thought about the impact. I should have, and based on what I did working for the city of Birmingham and ADA compliance, but I did training on a regular basis, on a quarterly basis for the Birmingham Police Department. One of the things I told them is that, the issues that you're going to face now are going to be people with mental illness. And of course, there's no way that you can know this just coming upon a scene or what have you, even if you have a person in custody or, there's no way for you to check this. And so this is going to help the persons with disabilities. This is going to help the community, persons with disabilities overall, and it's going to help the police officers in general throughout as they are out there risking their lives, but really not knowing. So thank you, Senator Elliott, for bringing this bill.
Sir, if I just respond to that, just off of her comments, and you're exactly right. Somebody who has a mental illness, you never know what sparks that or makes that individual turn from being compliant to violent in a drop of a hat. But people with mental illness, you don't know what their triggers are. And you don't know if if you're being cordial and everything's going great, the least little thing you say can trigger a violent reaction. And in our case, on August the 20th, that's exactly what happened. It went from 0 to 100, and when we don't know what triggered that violence from the individual. But again, if we had that flag, it could be tremendous for officers and the citizens. And let me just say this: in talking with this family, I know this family personally. Their son that was killed, and the mother said it best to me when we was talking to them. Mental illness is like cancer. I don't know of anybody who wants cancer, and nobody wants to suffer from mental illness. But anything that we can do to help law enforcement out there recognize people with mental illness is huge, because we're dealing with mental patients every day. Even in our small town of Bay Minette, we deal with individuals who suffer from mental illness numerous times in one day. And it's a regular occasion. So any help from you guys would be appreciated. And thank you for what you do.
Thank you, Chief. Senator Singleton.
Chief, just one brief question. Was there a weapon involved with the victim?
In this incident, the suspect gained control of the taser officer and was actively tasing the officer with it.
All right. Thank you. And I was just going to make a comment. If there was, it would just be on another ground for us to do background checks, for guns, because that would have caught it also if he had had a weapon. Yep. I'm sorry. Thank you.
Mr. Chairman.
Senator Smith.
I also want to iterate what Chief was saying to tell you this. About 2 years ago, I introduced a bill, and I think the Senate may have moved it. It got to the House. But under known circumstances, like, I'm taking you past what you're trying to get us to do when we go the next phase. Okay, we know this information now. That bill provided the opportunity for a social worker to go with you all on a known situation to address that. So I think I'm going to revise that to be complementary to what you're getting us to do. Like I said, a known one. I know if you stop somebody and you don't know them, bam, you see it, then you can do it. But it's also some of them, just like you said, history of mental illness, some of those people we do know. And those people will be able to get the professionals with you all once you get control of the situation to be able to help those people and get them where they need to go. So you all can look for that coming sometime. It may come this session, maybe next, but it'll be coming. Thank you.
Thank you, Senator Smithman. No other comments? If we could, we've got a first and a second on the giving the bill approval. Holly, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison,
Aye.
Senator Elliott,
Aye.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Bill is given a favorable report. Senate Judiciary. Thank you, Senator Elliott.
Thank you, Mr. Chairman. Appreciate your indulgence on that.
All right. Next bill up is SB 198. Senator Orr, you got the floor.
Thank you, Mr. Chairman. This bill, I'll tell you how it started, and then I'd like Mr. Mattson, if the chair would allow him to come forward and explain some of the more details about it. It started with a call from the Hartselle police chief, who's in the back of the room with us today, and the frustration of constant arrest under Class D. I think they were drug offenses, and nothing that the judges could do. And so just a revolving door arresting the same people week after week after week. And so what could we do? So I got a bill together, and then I contacted Mr. Mattson, and he had heard frustrations elsewhere with the Class D. And we added he added, and I certainly signed, we discussed on several different components. And I'd like the chair to, the additions to, if Mr. Mattson could walk the committee through, it gets into the Sentencing Commission and the judge's discretion and those kind of things, that he'd be a much better explainer than I am.
Mr. Mattson, would you mind addressing the committee?
Barry Mattson, Executive Director of Alabama District Attorneys Association and the Office of Prosecution Services. It's an honor and privilege. I appreciate you allowing me to speak briefly. The D felony was created in 2015 as part of the overall sentencing reform, and it took the C, which we always had A, B, and C misdemeanor, A, B, and C felony. It took the C and split it from 1 to 5 to 5 to 10. And what happened with the D was it wasn't that it created this new range. Rather than raising the misdemeanor threshold back then up to encompass part of that jurisdiction of the C, the decision was made to create the D. What happened was that there's a provision in the D felony that prohibits a person from being sent to jail. And not that anyone then or now is clamoring to send D felons to jail. D felons are possession of drugs, use of a credit card, it's forgery of a check, it's theft from $500 to $1,500. That's what D felonies are. Those are typically people that have, not always, but a lot of times have addiction issues and other issues. And so what's happened is, and I talked with Judge Mike Joyner last night, who is Shelby County drug court judge. He was on the Court of Criminal Appeals. Many of you know Judge Joyner, and he's a devoted advocate of drug courts. And he gave me permission to use his name and to say that the D has tremendously impacted drug courts across Alabama. Our numbers are down because if you're inclined to, it's a rational thought to steal $1,000 to get money for drugs, and you've got no support mechanism, you're not going to be able to get out of that cycle. And the way we do it in Alabama, unfortunately, it's the only thing we have mechanism is drug court and or DA diversion or mental health court, veterans courts. So those numbers have really plummeted. And it's not just anecdotal from people I've talked with. We had the lady that is AOC over the drug court numbers and drug court speak to our new DA orientation and confirm that numbers are down statewide, because what happens is a person is sitting there and they've got a choice. All right, I can go into drug court and live at the foot of the cross, abide by the rules, do what the judge tells me to do, and if I don't, the judge can hold me in jail, or I can take probation and be one of thousands of people supervised that I may never be seen again. And if I drug test positive, it's a technical violation and I'm not revoked. So we've created this class of crimes that have no accountability. And like I said, I'm not sitting here saying we've got to put D felons in jail. That's not the goal. What it is you want to be able to get those people in drug court and stop that cycle. And there's just no recourse. They literally, if I over the next 2 months went through every committee member here and stole $1,000 from each one of you, and when I got arrested, and I was brought to court, that's one sentencing event. The possibility of me going to jail is near zero. And unless I've got some other aggravated factors. And I know that sounds unbelievable, but it's true that $500 to $1,000 is a Class D. Now, if I steal $400, that's a Class A misdemeanor. The city judge downtown can send me to jail for up to a year. The district judge can send me to jail for a year. But on the D felony, we are unable to do that. And again, not that we want to, but there's got to be some accountability for these crimes so we can, stop that cycle. And what this bill does, all it does is it does not repeal the D, does not make it go away. It just says that the D will be, we returning discretion back to the judge. The judge would be able to, it would go in line with, and I've talked to Senator Orr about the habitual offender aspects of this, where we would limit it, where it wouldn't go up to an A, we would cap it at a B. If one of the priors was a Class A, say a murder, and then they had a couple of other felonies and they committed D, if they had a prior Class A, then it would bump up, but it would never get past a B or whatever limit that the body decided would be appropriate. But we just want to return that D when they go before the court. The judge has discretion to address that behavior, and right now they just don't. And the frustration across the state from business community, from law enforcement, and people that that come to me are just frustrated with the fact that we have created a class of felony that really has no accountability, even if you have multiple offenses.
Thank you, Mr. Matson.
Thank you.
Committee members, Senator Smithman.
Thank you, Mr. Chairman. First, I just want to set the protocol in order as it relates to this Sentencing Commission and that aspect of it first. I think if you go back in history of the Alabama State Legislature, Judge Pryor, who at that time was the Attorney General, and I was chairman of Judiciary, we established the Sentencing Commission. I was the sponsor, and he gave me the necessary input. So let me say that first. I fully understand this because I'm the one who sponsored the bill to set it up in Alabama. Now, I understand what you're saying, and I think none of these people in here know how close and how much I've worked with you over the years to make sure that we address concerns and issues as it relates to laws and law enforcement. I think I just wanted to say that to them before I said what I'm going to say. Okay. I want to let them understand that this is not some off the hip statement, but the frustration that is being seen, let me back out. The cycle that you talked about, this bill is going to send them into another cycle of staying in jail for the rest of their life. That's what the bitch offender. That's what this is getting ready to do. Yeah, it's gonna break that cycle, all right. It's gonna cycle them into jail for ever and ever and ever behind these Class Ds. These folks are sick. They are sick. If it's what you say about those drugs, they are sick, and we finna take sick people because of the frustration of having to go and arrest them over and over and over. And they hang out, or wherever these people hang out, because there's a frustration, we're going to get them completely off the streets. And we're going to put them in there in a bitch offender and lock them up forever. That's what this really does, in essence. I ain't talking about that's your intent. I'm not saying that's what you said. But my interpretation, and when I read this, and I had to get a preference that being the person who set up the Sentencing Commission. So I wanted everybody to know that I think I've have enough consideration on both sides in my head to understand what's going to happen over here with these people.
And Senator Smithman, I think there's an amendment that might address some of your concerns.
Mr. Chairman, I have one.
It may address some of them, you know, but I have a serious concern with that, with the aspect about the split sentencing and how that's treated, and I think that that's the purpose. One of the purpose for the D was to have a category above misdemeanors because the value of things had changed. I remember I hearing a whole bunch of conversation about things at $500. Now if you get something it's $1,000 or it's $800 or $1,200. And I think that was in part to address that and that not be a misdemeanor. Now we're changing D, and really we're just making it a C in terms of what we're trying to do right here. That's just a fact. All the thing that is just an alphabet, but we're treating it like a C. So if we're going to do that, then the legislation needs to abolish D's and go back to where we were. And yeah, because this is that's not the case here. This is treated just like a C. And when it's treated like a C, they're going to be treated for a bunch of purposes. They're going to be treated for any other purposes that the D, opposite of what the D was set up for. So, you know, I and this is not just at this alone, but I got some serious concerns about where we headed with this. I mean, this whole thing, as we talk about this crime situation, I mean, as I said earlier, I know my record speaks for itself. You know, if you go through the 10-year period and look at every law that we passed when I was chairman of Judiciary, I think you'll see that I'm all for dealing with criminals. But I think that, you know, sometimes the pendulum swings too far, and I can just say this in close, Mr. Chairman. Every bill that has come through here, just about, not this one per se, the first thing we start off talking about, 16-year-olds going to be treated as adults. Okay, we trying to put these teenagers back in prison. These are kids who are in the 10th grade in school. So we getting ready to throw them in jail as adults for everything. I've seen 4 come through here. The first stars out talking about it at age 16. You know, and I've really got concerned about this whole aspect that we are kind of going backwards. And the bad part about it, there are going to be innocent people under the name of trying to get the ones who doing what they're doing, because we're going so overboard that we're going to be snatching innocent people. You know, we got a gang bill. You know, They say, I'm just making a point. It said that if you're an associate, I stand up at Chevron on 6th Avenue where some of everybody there when I go get my gas. I stand out there and talk to them too, because that's, you know, I live in the hood. I want everybody to understand I live in the hood. I live, anything that you talking about, I stay in the gateway. Gateway to West End. If you know about West End,
Yes, sir.
The gateway comes straight past where I live and going on to West End. Okay, so yeah, I understand what you're saying. But to go that broad like we doing now, we trying to lock folks up and just give the perception that we trying to lock them up so we feel these new prisons that we building. You know, in other words, it's institutionalized slavery. That's what it's beginning to look like. And I have serious concerns about that. Thank you.
Thanks, Senator. Senator Bell.
Senator Smithman, I had some of the same concerns, and when I asked Senator Orr, he just handed me an amendment I think clears up some of what you're asking. I guess to make sure I see Mr. Bennett right out there, I'd love if he can come look at this amendment and give us his understanding, because I consider him to probably be the expert on this. If he's available,
Mr. Wright,
available to do it.
would you mind coming to address the amendment? Are you offering that amendment, Senator Bell?
I've got it here, but he's welcome to offer it. I
Okay.
think the members all have it. It's one
Senator Orr, are
page.
you offering that amendment?
Yes,
Okay.
And what this does, my understanding is gets into the HOA, and if you don't have 3 Ds, you're not going to get a Class A after 3 Ds. And under the Habitual Offender Act.
And I think that there was a valid concern by Senator Smitherman there as it relates to that.
Yes, I agree.
So,
Didn't want that. And let me say this to Senator Smith. I was asked, do we just want to get rid of the D? And I said, no, don't want to get rid of the D. Now, obviously got still some concerns about it, and that's fine. You're probably more knowledgeable about criminal law than I am. I hadn't been in a criminal courtroom in 25 plus years, so. We used to have court-appointed attorneys and for criminal appointments back in the day.
all right, Mr. Wright, would you care to address the amendment? Are you prepared? And if not, then we'll give you a little time, or we'll pass over you, but I hate to put you on the spot. I didn't actually, Mr. Bell did, Senator Bell did, so.
No, thank you, Senator. I have not had a chance to see the amendment. I'm going to look at the amendment, and I'm going to look.
I just saw it this morning, but I'm aware of what it does, and I've been speaking with Senator Orr to address your concerns on habitual offender and to limit its application on habitual offender, because that's, and you're right, Senator, you've worked with us law enforcement DAs on bills for years, and you're a friend, and I hope you know that, and I respect you immensely. What we truly want to do is to take the D, because we're seeing, over and over and over and over and over and over. And at some point in time, there's just, there are, Senator, you would be amazed at the multiple offenses of D's that people kind of get in that cycle. And and we really can't do anything. And if they go, they're just not choosing to go into a program where we can do anything for them. And so limiting the application of habitual offenders so we don't create that cycle where we're sending Ds to be treated like As or the high end of Bs, that kind of thing, that's not what we're wanting to do. And the bill you have in front of you, that's correct. And we worked on amendments the last 2 or 3 days, running it through the different stakeholders and people that we've been working with. And I believe we've got an amendment. Certainly, it's our commitment that we don't want to move it, especially on the floor, until we have some accord on its application under habitual offender. We don't want to have that broad application there. So that's not our goal. It was not our intent. And what we did was we took the D, and put it in line like other felonies, and would be treated, the judge would have the same discretion the judge would have, she or he would have, as if they would have had with a C. And so that's what the bill I have in front of you does. And then our goal would be, and of course we're willing to certainly dial back any habitual offender application like you've referenced here.
Senator Singleton, and then let's address, I guess, the amendment to the best of our ability, see if we want to adopt the amendment or not, get back on the bill and continue discussion if there is any. Senator Singleton.
I just want, was there any consideration of being able to close the gap from the A up versus from the D to the C?
We've
that way judges will have the discretion, just like do with an A, to be able to sentence them to a year if they want to. If you could feel the gap there, then it doesn't become a felony to where they could be a part of the Habitual Offender Act.
What we were talking about with Senator Orr, we were working on right up to the committee hearing, was if a person committed had a D, and they had 3 or more priors, and one of them was a Class A, which is rape, robbery, murder, then that would be treated as a B.
I'm an A misdemeanor.
Oh, A misdemeanor. No, we don't address misdemeanors. And I'm
saying, if in terms of, we talk about that gap between the A misdemeanor and the D, right? That's where we missed it when we did it in 15.
Well, the misdemeanor goes up to $500,
right,
and the D goes $500 to $1,500. Right. There was some talk in 15 of raising that misdemeanor threshold up and not have a D, just raise the misdemeanor up. And that wasn't done for whatever reason at that time. I wasn't in those meetings within the body, but it was decided, rather than raising misdemeanor, it was decided to create this D, which really became kind of a fiction, because you created this D, it looks like there's another felony, but then then they kind of took away the ability for the judge to tell the defendant, even threaten them with jail, say, look, if you don't go to drug court, if you don't follow the rules of the court, you can go to jail. You have that in a misdemeanor, and you have that in a C. You have that in a B and A. You just don't have that in a D, and that's what we're wanting to do.
All right.
I just want to understand.
Yes, sir. Thank you.
Quickly, I want to.
If we can, and then we'll
I will.
get on the amendment, and then we can continue discussion on if it's amended. But yes, sir, go ahead.
Well, why can't we just simply amend the D statute to allow that discretion by the judge?
Right.
Without doing all of this, it's subject these folks to a habitual offender and everything else. And that's even with the amendment, it still subjects them. In my opinion, it just stretches it out further before you get there. And am I kind of right about what I just said?
Yes, that's what this bill does. But in addition, it does put the D in the ticket line for habitual offender, and that's what we've been talking about, limiting the habitual offender. Give the judge discretion, but limit how far it can go on the habitual offender. Agreeing with what you're saying.
What I'm saying, I don't think that it ought to go anywhere on the habitual offender.
Right.
And I think we need to get a judge of discretion. All these problems that been shared with you is that I think can be addressed if we give the judge the discretion, and because then the judge can make that decision. And I say that because I there again in another life before I was a lawyer, I was the clerk of criminal district court for Judge Pete Johnson, and Judge would just simply, when he see these situations right here, this is what he would say. He would say, "Get the jail thing ready. They trying to break back into jail." And he said, "I'm going to keep them for the weekend." He said, that's what he would tell me. He said, "Monday, I'm going to bring them back up here, and I'm going to see where they are at that point." So the judges used, I'm not saying that D didn't do what you just said, by taking discretion away, but judges use those discretions to get these folks in line. That's because they didn't go to report to something or something. He said, "Since you can't report, go spend this weekend in jail. I'm going to let you have money. If you don't go report, then I'm going to put you back in there." Period. See, so they can do that, but what we got to do in this situation here is forget this habitual offender stuff, period, and come back and put the discretion in there for that judge to do whatever it is that needs to be done so that you don't have the person not being in the breath of the court itself and them having the total control of it. See, what we doing here, we flipping the control from the judge to the Department of Corrections by making them a habitual offender. That's what we're doing. It needs to stay where we saying that they don't have it, and that's with the judge. So I'm through, Mr. Chairman, but I do want to say this. I'm talking to the sponsor itself. We need to fix this in here, because I'm just telling you what's getting ready to happen. We talking all this, we need to do this and do this. We walk out of here, it ain't going to get fixed. They're going to get on the special order calendar, and you're going to be standing up there saying, "Well, why you didn't bring me your amendment?" And it ain't for me to bring the amendment. It's for you folks who doing this bill to correct it. So they put it out there. I mean, they hear the problems. Y'all hear the problems. Y'all both be the minds that's thinking about this. So I'm saying go and find a way, I'm asking, to do what you want to do and not make this associated with the habitual offender. Thank you, Mr. Chairman.
Valid concern, Senator Smitherman. I think, one of those being that if you had 3 Ds at one time, even though it's one occurrence, you may get charged with 3 D felonies, and therefore, under the habitual offender, the next one you get popped really hard. So valid concerns. We're on the amendment. It's had a first by Senator Orr, second by Senator Weaver. Let's take a vote on the amendment.
Before I vote, I still want to understand what his amendment does. I don't know what it's doing.
Mr. Wright, have you had enough time to look at that amendment? If you could give us just a brief explanation, and I think it allays some of the concerns of what's been talked about here. Is that an accurate statement?
Sure, and I have a question. Is it possible for me to see your exact amendment, Senator Orr?
Yeah, I don't have but the one copy. You can get, it should be 1 page.
Okay. Yes, so on this amendment that I'm looking at right here, it would remove Class D convictions from the traditional habitual offender enhancement. So a Class D felony would not be eligible to receive a punishment at a Class A or B or elevated C level. So it would remain the law as it stands right now. If someone's convicted of a D and they had 3 or more prior felonies, the maximum sentence they would be eligible to receive in a court would be 10 years.
And in that amendment, that would even be the case if they had a prior murder or prior rape as one of those priors. So what I had talked to Senator Orr about was if one of those priors was a violent Class A, like a rape robbery, then that person would be this. If they commit a D and they've got, say, 3 prior Ds, that's one thing. But if they commit a D and they've got a prior rape and a sodomy and then a stolen check, then I believe that should be treated differently than if they've got 3 prior Ds. So where this amendment just, and it's not our amendment, I think it comes from the courts, possibly. I'm not sure where it comes from. I just saw.
Well, it's Senator Orr's amendment, so.
Yeah.
Okay. It takes, it says that no D is subject to habitual offender. And so this would, but I do think it would be appropriate if some of the priors are A's and B's, that would.
Let me say this, it's my desire, let's get back on the amendment, we got a first and a second. I think that solves some of the concerns as it relates to habitual offender, the amendment does, to the extent that there needs to be other work. If the DAs aren't happy with that amendment and y'all think it needs to be tighter or better or stronger, y'all work the committee members. If we adopt that committee amendment and get the bill out here, then y'all certainly have the opportunity to work to make it more punishment, more punitive. Okay.
He has my word, and I want to talk to Senator Smitherman as well. He's brought up more than just this HOA stuff, so I want to hear him out. Now, I guess I'd just bring his example. 2 weeks ago, Senator Figures had a concern on that ethics bill that we passed yesterday with the exculpatory evidence, and she brought up the idea of knowing who your accuser is, and she wasn't even in the chamber yesterday. I got an amendment drafted when that bill was on the special order Thursday and put it on there yesterday as a, again, she didn't do any of that, and I hope it's what she wanted, but all to say, I respect my colleagues' opinions, and I'll certainly work to accommodate as best I can, even if they're not here.
Thank you.
As best I can.
All right, so we're on the amendment. How if you call the roll on the amendment?
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison.
Yes.
Senator Elliott, Senator Figures, Senator Gavan, Senator Orr,
Aye.
Senator Singleton, Senator Stutz, Senator Weaver, Senator Barfoot.
All right.
11. Oh, Smitherman, sorry. Okay, 12.
All right. The amendment is adopted. If no further discussion, let's, if there's any opposition, using previous rule. If not, we'll use previous rule. Any opposition to that, Senator Coleman Madison? If not, we can call the long roll on it.
Well, you don't have to call a long one. I'm just going to abstain. I just want to make sure that these things are addressed because we just passed a bill in here that you don't have good time. And so I'm just wondering how all this fits into the whole package here. So I'd like to see something conclusive that we can all agree on first. So I'm abstain. If you want to use the last roll.
Thank you. And I would urge the OPS, Mr. Madsen, if you will, any concerns that have been brought up today, go directly to the members and address them, listen to them, and try to work to, come to some agreement or understanding, at least in fact, of what the bill does. Okay. All right. That being said, using previous role with abstention from Senator Coleman Madison, bill is given a favorable report. Thank you. Next bill on the agenda is SB 206, Senator Chambliss.
Good morning, Mr. Chairman, members of the committee. Those of you that have been here before have seen this bill before. This is a bill that adds a section to the statute dealing with shoplifting. Currently, it's my understanding that these are prosecuted under the theft statute. And as you know, over time, the technology has advanced with registers and scanning and barcodes and different things. So I feel a need as suggested by police chiefs in my area that we have a code specifically dealing with shoplifting.
Senator Smitherman got a motion for a favorable Senator Bell. Senator Smitherman, you recognize.
Thank you. Senator, you and I have had extensive conversation about this issue. I mean, over the last couple of years, really.
And your 2 or more is still in there.
But I'm gonna just tell you something. I use the analysis of an airplane when I try to give these what I'm getting ready to say. The plane, you have the body of the plane. The plane is looking straight down the runway. But what happens is that because we are driving this plane and it's going straight down the runway, we don't look at the fact that the plane has wings on it. And these wings are going to take out everything that's on, because we're looking down the open track. This is an open track. But we're not looking at what the residual, what these wings are doing to damage and things out here that doesn't even relate to going down there. I.e., I have 2 examples, and I was looking on here, and I think this may be the section. I could be wrong on the section, but because I hadn't looked in my code this morning through and read that whole section. But we're talking about section 13A-8-226B. It says down here to list various acts which shall constitute prima facie evidence.
Senator Smith, where are you at on there?
I'm in your book on the analysis under his name under the summary of the bill.
Okay.
I'm at the bottom, the last one. You see down there? Was 13A-8-226B. And it says that it lists various acts which shall constitute prima facie evidence that the defendant acted knowingly in the commission of the organized retail theft. First of all, just make it clear, prima facie means just point blank that if you do something, then you guilty. If it show you just flat out guilty. It's not any mitigating or anything. Now, you said, what are you talking about? Under this act, yesterday morning, I could have potentially been found guilty of this. Why? Because I went in the service station, paid for the gas, put in my automobile to come down here, got me a bottle of water, and I got me a 50-cent package of Juicy Fruit chewing gum. I paid for the water, I paid for the gas, and just flat out forgot I had the gum in my hand. I walked to the door, and I said, I got to pay for this, go back. That's too late to this bill. This bill said if I pay by that cash register, I am prima facie guilty of doing this. Same thing in Lowe's. You go into the garden area. Cash register sitting right there. I got a buggy that I've been in our Lowe's, I said Walmart. Because same thing, we got a garden area out there. 9 times out of 10, I'm over in the sporting goods section, which is right next. Anybody know about Walmart on Lakeshore know what I'm talking about. You come out of there and go into the garden. The cash register sitting right there. The flower plants, the pottery, all that is on the outside. If I push that bucket past that cash register, I am guilty, prima facie. That can't be. That can't be. And I know the first thing that's going to be said to me, well, that person on the register or whatever, or those people, they have discretion. I know that's what I'm getting ready to hear. And y'all know what I'm getting ready to say. black folk don't get discretion like that. That just tell it like it is. Now, you know, I mean, this ain't no racial stuff. It's just facts. See, that's facts. Okay.
Mr.
I
Senator,
gave my analysis on the floor about the facts.
I'm actually going to tell you something different.
Okay.
I think there is a little bit of room in there that we need to address that point of sale past the cash register for issues just like you said, like the garden center, like the ice bin being beyond the cash register. So yes, that is something that we need to address.
Okay. So we need to address it before we move this bill. That's all I'm saying. Because I just said it before. I know what's going to happen. We get it out there some kind of way. It's going to get on special order. You may not even request it. It just may be one of those bills because that's the discretion of the Rules Committee, that put on there. And then we're going to be up at the mic doing the BIR. I'm going to be talking to BIR. And first thing I'm going to be at way amendment. And the weight should be on the people who bring these bills to address and whatever the concern and correct it if they're going to address it and correct it. Not on the person, not on the other legislator. I mean, unless they got an amendment they bring or something. I mean, because, I'm just being honest, because the person who sponsored knows when it's going to come up. You see what I'm saying? They know, you got an idea. But so I had to keep, I said that twice, and I said it, not at this meeting, I said the last one. Before we stand up there, that mic, that ought to be already, and everybody ought to know. Okay, I would hope we would do that, so I don't have to go up there to no mic.
Yes,
be doing talking whatever deal. I would like for us to have this stuff corrected so we can address that. So I just wanted to share that. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Bell.
I just want to say one thing, and I think this bill is kind of most of these people right now are being charged anyway, whether they go through the cash register or not, based on their intent of hiding the stuff in their purse, hiding the stuff on their pockets, things of that nature. What I'm seeing in the municipal courts that we work, and if you always look, Walmart has great video. If they're changing tags or if they're moving stuff to the server, they always look first as they're doing it to make sure nobody's watching them. I know the Walmart that I know of, they're having a couple 100,000 a year in lost based of thefts. So I love the bill because I'm tired of our businesses being toted away. And that's what's happening even in Pell City and some of the others. They're being toted away, and it's the people that, it's our own citizens. I hate to say that, but most of them are our own citizens, our own people living close by. But that's why I like this. It changes some things and gives the law enforcement and prosecutors a little bit different weapon, but right now they're charging them either with a Class C felony based on the dollar value or the misdemeanors. But we're seeing people go in and take a buggy and put merchandise, large merchandise in the Home Depot and places, and just shove it right on through and keep going. And that's my only issue is we've got to protect our businesses, and I think this does that to a certain degree. But I'm still seeing cases where if they hide it, put it in their pocket or things, they've never passed the register and still getting charged and convicted based on their intent.
Senator Van.
I acknowledge this is a problem. We've got to do something about it. But I think we do need to be conscious about how we do it. I'm sitting here thinking about, Senator made me think about this. I had 2 cans of tuna in the back of the buggy, go through the cash register. I hate those self-checkouts. She didn't see it. I forgot about it, get in the car, and I'm like, and they were not in, they weren't in the bag. And I'm like, what's going on? So I go back in and pay for them. And she says, this happens more than you think it happens. Mm-hmm. And, I hear about people all the time that, have a case of water under the, something like that, and just forget to, because you tuck it up under the buggy. And so I just think it seems like it needs to be some little de minimis in there that if we, it's not I get that it's a pattern. But anyway,
Mr. Chairman,
I will say this though. I think on that section it says 2 or more within a year. Senator Coleman Madison had a comment or question, and then Senator Smithman.
Yeah, I did have a question on page 5. I'm just looking at the shopping cart, and in some areas, this is number 9 on page 5. In some areas, people don't have transportation, and they'll go and they'll bring the shopping cart with them. Well, of course, if you remove the shopping cart with the intention of depriving the possession. Well, in some communities, that's what you find. I mean, I hate it because they're all over, they leave it all over the neighborhood. But the thing of it is, a lot of people don't know that that's committing a crime. They don't think anything about it. Is there going to be any posting or signs or whatever to let people know that there's a penalty? Now, I have seen some. Aldi's, I know they've got the chip on it. You can't take it off the lot. They've got a stopgap thing on theirs. But
Right.
I would hate for a person to be locked up for a shopping cart.
Well, the point of all of this is that our retail stores are being deprived of the goods that they have purchased, the carts. And when we do that as a society, that adds to the cost that we all pay.
And I totally agree with you. I have seen stores, I mean, usually Walmart comes into an area. Walmart survives usually because, everybody shops at Walmart. It's a one-stop. And, and in the past several years, I have seen several Walmarts had to close. And an example was Senator Smith been talking about. I mean, in my own area, I noticed after church, I would always go to this particular Walmart, and I would go through the garden center. One Sunday I went there, and the garden center was locked. It had padlock on it, no attendants there. I'm like, okay, we got a shoplifting problem here. Mm-hmm. And I knew that's exactly what it was, so I just went on to the one closer to home. But that Walmart closed, and everybody realized that it closed simply because there was an increase in shoplifting, and it was something that was just known. But we do ourselves as a community a disservice. But I think you have a good bill. As a matter of fact, one of the DAs called me about this bill this morning and said that they supported the bill. So you've got some support because people understand. I just think that the questions that have been raised, there needs to be some tweaking in here to try to address that, hosting or whatever, or cash register thing, because we've all, and I would hate to leave it up to the discretion of somebody who didn't like me.
Everybody likes you.
Your skin going to have a lot to do with that.
All right. Senator Smith.
I'm going to be brief, and I want to say this, is that I've heard numerous comments about what we're doing here. And yesterday and today reflects my concern. Every one of these comments that talk about what the business. Nobody's talking about the citizen. Two folks came up to me, lobbyists. All they talked about is the business. Now we're talking about what happened to the people. At some point, we gonna have to realize that we also represent regular citizens. Just regular citizens, not the big money folk, none of that. The people who voted for us were these regular citizens. They ain't got nobody in this sitting out there right now. They ain't got nobody gonna be up on 7. Not regular citizens, but us. They ain't gonna have no lobbyists. They ain't gonna have nobody to lobby us on the other side of what you hearing in here, as the majority of y'all, I think, have expressed as a concern. But you ain't gonna hear that. If you don't hear from one of us, I ain't talking about us over here, I'm talking about the whole committee, you're not gonna hear it. So we have to open up our minds and not just be like that airplane that we trying to make sure business don't have to be. And I got my own business. It's the same thing. I had somebody come on my porch and steal the umbrella off of it when it was raining. Go walking down the street. They go, oh, that's an umbrella. I'm sitting in my office. They wasn't snatch the umbrella and walk down the hall, down the street. So, I mean, I understand the feeling when somebody takes stuff from you. But still, we have to be flexible enough in our mind to also put ourselves in the place of a regular citizen and find a balance. That's what these scales of justice are for. It's 2 scales. You got the business over here in this issue. Boom, it's a lot of weight. You ain't got nothing but the cries that you're hearing in here over here, and it's just kind of right here. We got to find where it's right here. Okay, thank you.
Thank you, Senator. That being said, no other comments. I'll let you call the roll.
Senator Albritton. Senator Bell. Senator Carnley. Senator Coleman Madison. Senator Elliott.
Aye.
Senator Figures. Senator Gavan. Senator Orr.
I don't have them.
Senator Singleton.
I will with.
Senator Smitherman.
And I'm abstaining just because I'm waiting on the amendment. I'm not abstaining because I don't believe this man is going to do what he's do. You've been road tested with me. I know you keep your word. You do what you do. So I'm not even worried, okay? But I'm just going to abstain because I support, and I want the DB and the folk to know, you know, and we just got elected, so this ain't no campaign talk or word about that. But I support what they are trying to do because it's not right for folks to go in and just rip them off. Right. It's not right, and I want to say that. I don't want them to even think I think that that's right. It's not right what bit. But at the same time, we have to address these issues as we see it.
Thank you, sir. We will work on those wings.
Senator Stutz. Senator Weaver. Senator Barfoot.
Aye.
9, 1, and 1.
All right, Bill's giving favor report. We're going to jump around a little bit here. We're seeing colleagues from now. And thank you, Senator Chambliss. Seeing a couple of colleagues from the House, judges in the House, and come on up, Judge. You've got HB 37. If you will address the committee and give us your thoughts on it.
Yes, sir. Thanks. Thank you, sir.
Mr. Chairman.
Yes, sir.
The committee can go otherwise, but I move favor report, and I just tell you why. That the first phase of this bill, I actually sponsored it, of dealing with the terrorists with the Jewish synagogue out there off of Montclair, the threats that were made. So I know what this bill will do, and I've just moved favor report right off the bat.
Motion for favorable. Senator Gavan actually jumped ahead of you there, Senator Bell. Any opposition to using previous roll? And if you will,
no, I don't want the previous roll.
All right, let's call a long roll then.
Aye for this.
Senator Albritton. Senator Bell. Senator Cornley. Senator Coleman Madison. Senator Elliott. Senator Figures. Senator Gavan. Senator Orr. Senator Singleton. Senator Smitherman.
Aye.
Senator Stutz. Senator Weaver. Senator Barfoot.
Aye.
Thank you, sir. And while I got Senator Smitherman in a pretty good mood, I got 3 or 4 more bills on. Thank you.
Thank you, Judge. All right, Bill's giving favor report. Next up, we're going to try to take care of one of our House colleagues, Representative Estes, if you could come up. Explain the bill to the committee.
I sure will. Thank you, Mr. Chairman and members. My goodness, I looked at that, I leaned over and I looked over at Senator Smitherman, and I'm thinking, man, I wish I could get that same courtesy. Let me explain to you briefly what this bill does. I will tell you it passed unanimously downstairs in the House. We actually got it out in about 5 or 6 minutes. What we're trying to do here, members, is simply close the loophole. As most of you already know, because many of you are attorneys and judges and held positions that I've never had, but we're trying to close the loophole because most of you know it is currently against the law in the state of Alabama to discharge a firearm either inside an occupied or unoccupied school bus or an occupied or an unoccupied school building. We apparently have a loophole where we don't have that same guidelines for just discharging a weapon on school grounds. And for school grounds, you're also talking about there could be playgrounds out there. And so that's what we're trying to do is close that. We also have amendments that we carried on the floor that made this apply to adults 19 years of age and older. And I'm trying to think real quickly what the other one was. Oh, yeah. Also, it will not apply to property owned, as many of you know, as 16th section land, because a lot of school boards lease that out for hunting. That's not, we're talking about grounds where there's instruction taking place in school buildings. So that's simply all we're trying to do is close that gap.
Thank you, Representative Estes. Senator Smitherman.
I just want to quickly tell you that I appreciate you bringing the bill.
Yes, sir.
I saw something the other day on the news. Folks are so spooked now. I mean, somebody hollered, they thought they heard a gun, and everybody in the whole thought they heard a gun, and everybody took out the running in the place, and and everything like that. So you to be commended for bringing this bill for that purpose, and at the right time, I move for favorable report.
Got a motion for favorable. Second, Senator Coleman Madison. Any opposition to use previous roll? Hearing none, thank you. Bill's giving favor report. Thank you, Representative Estes.
Thank you, Chairman and members.
Thank you. Let's get back on the regular order of the agenda. SB 97, Senator Gavan.
Thank you, Mr. Chairman. This is the bill that closes the what's referred to sometimes as the Jimmy Spencer loophole. This bill has already passed the House. I anticipate passing the House, assuming obviously subject to a vote of the body, that we actually will pass the House bill. Would like to go ahead and get mine out of committee today if we can. I know that the chairman has got some specific concerns about it that I've agreed to work with him on the floor. And then there's an amendment that has been drafted too. So I guess at this time, you want to offer them?
Senator Gavan, you're offering the amendment to SB 97?
Yes, sir.
All right. That should be in your packet.
What does it do, the amendment?
I think in fact, and this is not wasn't the amendment that you and I talked about. We'll work together on that, and I'll share with the committee my concerns. As prisoners shall be immediately notified by the Department of Correction of any new charges pursuant to Subdivision 1, which I think they should be. My concern, which I don't think this amendment fully addresses, and I'll give you a really quick, for instance, you have an individual who may, for instance, have a DUI in municipal court somewhere, and once they plead not guilty, they get out. Prior to their court date, they get arrested, maybe on a felony, they're in DOC custody, and they're not eligible for parole because that adjudication has not happened on that DUI. DOC doesn't notify, the municipal court. The municipal court doesn't notify DOC, and nobody's talking or bringing that individual back to be adjudicated of that. And that instance would preclude them from being, eligible for probation. So I have a real concern about that. And I think, I appreciate you sitting down and listening to me, and we'll continue to work on that. Senator Smithman.
I just fully agree with you. I agree with you in that aspect about that. I've seen that happen numerous times.
Right.
That something of that misdemeanor nature even, and you've done all this major stuff, and now you think you're getting out.
And you got
municipality. They ship you right back over there. They won't have the hearing, and then ship you back over there that you've been in jail 2 years, 3 years, 5 years, whatever it is. Now all of a sudden they shipping you back over there. So I stand waiting to see how your amendment is going to look, but I support what you're trying to do.
Thank you,
because I've seen that numerous times.
Thank you, Senator Singleton. Let's look at. I don't have that today. Do you have it? Okay. Committee members, have y'all seen this?
I hadn't. Would you read
it? That is the committee. That is the same committee amendment that I guess Senator Gavan just offered. I still don't think that corrects fully the problem, so I'd like to continue to work on that with you.
I would move adoption of the amendment.
I second.
Got a first and second on the adoption of the amendment. Any need for long roll or any opposition to previous roll? Hearing none, the committee amendment is adopted. Back on the bill. Any further discussion? With that caveat, got a motion for favorable. Second by Senator Elliott. Any opposition to previous roll? Hearing none, that amended SB is given a favorable report. Thank you, Senator Gavan. Senator Weaver.
Thank you, Mr. Chairman. Today I have SB 83, and we're looking at the definition of child abuse. And I bring this because we had some specific instances where we realize that we really need to update the statute to be able to look at how we protect our children better. In daycares now, we have nanny cams, security cams, things like that, where we are able to hold people accountable for their actions, but we need the statute to be able to uphold that as well. Specifically, this allows for individuals to be punished when they're not taking care of our children like they're supposed to. And specifically in an Autauga County daycare, we had children that were slammed headfirst into crib rails and shoved with both hands with caretakers across the room. And during the trial, it took hours and hours of deliberation around the definition of maltreat. There was just a lot of discussion that should be different than harassing communications, which is the way the adult injury is defined. I also have a mama from Blount County here today in the audience that had the same issues with her child being abused in daycare. So this just allows us to hold those accountable who abuse our children. And when we receive evidence such as nanny cams and security cams, those children being harmed, and the responsible person needs to be held accountable for that. I do have an amendment to the bill that we have worked with DHR on to resolve their issues related to the work that they do. So
what was their issues before? Because we hearing the solution and the amendment, but what is the issue that this is trying to correct?
Okay, so the issue is in Alabama, if you cause physical injury to an adult by striking, shoving, kicking, subjecting them to physical contact, it's a Class C misdemeanor, currently punishable up to 90 days in jail. This allows for individuals to be punished for doing the same thing for children under the age of 6. It takes that. So
I saw 17, and what that mean? I saw 6, but I saw 17 too.
I think that's the incompetent. If there's some other disability
yes,
incompetency.
if there's something, if they're nonverbal or if they have a mental handicap. But this allows us to use that same language that we had in Winston's law. You may remember Senator Chambliss had that, I think, in 2016. And it just expands that definition of child abuse so that.
I'm going to ask the question. What happens then? Listen to this, because I got some video that I saw this, and so I want to ask this. What happens then when the child attacks the teacher and the teacher has to defend themselves? Because I know a teacher got charged with the abuse. In the film, the teacher is going up the steps and the child, in other words, the child blocking the steps, and they said, look, it was that way it started. Somebody standing on the step. It was teacher was trying to just retrieve away from it, and this child kept coming. So now the teacher's got to move the child out the way, and now all of a sudden the teacher gets charged with this. So where do we make a distinction? Okay, we need to do that. This ain't just conversation. We need to do somewhere in there that it deals with the fact that when they get attacked, because the defense. You got people who don't think little Johnny does nothing wrong. So little Johnny come home and say that's the truth. That's a fact. Everybody know that. That's a fact. So now we lighten out to the DAs to get an abuse. Because mama said little Johnny said, and now this teacher sit there charged with this, but Johnny attacked the teacher. Okay, so how and I said it, I know what you're trying to do, but y'all remember when I always say this, when you open up Pandora's box, all you want to come out of it is what you're doing right there. But this other stuff I'm talking about is still in this box. And if we're going to deal with the issue, then we got to deal with both sides. So what's in there that's going to address that concern?
Would you allow CJ to come comment?
Mr. Robinson, if you would address the committee as it relates to those questions or concerns that Senator Smithman has raised.
Sure. Good morning, Senator Smithman. My name is CJ Robinson. I'm the district attorney for Chilton, Autauga, and Elmore counties. To answer your question,
and I want to tell you, I'm familiar with y'all. Y'all do a good job.
Thank you, sir.
Yeah, you don't remember me, but you assisted me in something real well. I just tell you that.
Well, thank you. We try to do the right thing, even when it's not easy. So thank you. To answer your question specifically, I think it may go to the language of a substitute bill that we worked on with DHR. DHR had a question regarding some of their dependency issues, which is very different than what we do, clearly. But we realized that we all had way more in common than we had separate on this bill. So we worked out some language, and actually it made it much simpler, and I think it goes directly to what you asked, which is a very good question. And I don't know if you have the language of the sub, Senator Weaver may can speak to that, but if okay. So if you look at the definition, we added willfully mistreat. So under the current child abuse statute, if you torture a child, I think we can agree to that. If you cruelly beat, the question was maltreat. So with your question, we added the willfully maltreat. We gave a definition to mistreat. And on the definition, and this was a lot of great work done by Trish Melberg over at OPS, any intentional behavior that inflicts unnecessary or unjustifiable pain or suffering on a child without causing physical injury. So that would get into, you're not discounting self-defense. You're not discounting the defense of necessity. You know, you're not going to have somebody come up and say, oh, well, somebody pulled a fire alarm and this child wouldn't go, so I shoved him. Like, all those things come into play. You have to look at the unnecessary or unjustifiable portion of that under the definition of mistreat. Now, in our situation in Watauga County, we had a situation to where there was over 100 years of prosecutorial experience in a room, multiple supernumeraries, and we watched these videos, and we sat around for literally 3 days trying to figure out, what do we do here? And we went back to, I will say this, I've never been a Supreme Court justice. I complete respect what they do, but they did something extremely just fascinating in the 60s and 70s when obscenity was up. And you had all these things in our country, which that may be in your time, it was before my time, but they chose not to define obscenity. They didn't put parameters. They said, I know it when I see it. And that's what we did in that case. And when you take a child who's nonverbal, this under the age of 2, and you grab that child and you pick them up and you slam their head down, or you shove them like an offensive tackle, and you do it, and this camera's up here, and you don't think the camera's recording, but it is. And this lady comes in to be an intern, and she sees this happening, and she says, this isn't right. I got to get out of here. Like, she could feel the walls closing in as she's seeing this. And she knew it was abuse because she knew it. She saw it. So she reported. And when they pull this video, you've got 30 days of this going on. Now, I can tell you, day one, it may went for longer, but on day one, it wasn't that extreme. But every day, they got more bold, more assaulting on the children. And it was, I had a grand juror, when I watched these videos, he stood up and almost punched a hole in an oak pew. And seeing this stuff, I had to go to the definition of maltreat. There's case law. Does it fit? I don't know. At one point in time, maltreat was an act of omission. The child's sick. I don't take him to the doctor. The child died. You know, those type of things. Then maybe years later, it gets expanded to, well, I can do an act to be maltreat. We had to win a series of hearings over a 3-month process. We had to win probably 6 hearings to get to try the case. The jury watching these videos, the grand jury indicted 44 counts per 3 defendants. The jury came back with 21 counts of child abuse guilty. I get it, because it was so hard to define, but under this, I think it would have made it much simpler to say, wait a minute, you just grabbed a 9-month-old child and basically threw him like a football into the side of the crib. That can't happen. And it's different because we have nonverbal children. When you have children who can go to the parent or go to a Butterfly Bridge, a children's advocacy center, and say, this happened to me and it hurt. Or they tell mom and go to the doctor, hey, there's an injury. Well, these children mostly are nonverbal. I know the situation in other counties and my counties, through this technology that we have, which is a good thing. It's similar to body cams. Body cams have been a good thing for law enforcement. These nanny cams and daycares are a good thing because it's weeding out some of the more offensive things that we see. But when we have that under the current statute, you've got to deal with this physical injury component. And if the child can't say I'm hurt, how do you take it to a doctor to prove that? This includes those acts to where maybe the child, I don't know today, and I can't take, and I can't have a doctor say, hey, there's this, there's that, there's deep tissue, maybe 30 days that's healed. This would include those situations, and you're almost going to have the audio or video like we have in these daycare situations, because we don't want to disincentivize parents from spanking children. Lord have mercy. My 5-year-old and 3-year-old, I don't think their pain receptors work. I can't imagine what I would be left with if that didn't work. So we don't want to and I appreciate DHR coming to the table and we work through those situations. And I hope we've got a compromise here that everybody can live with. So I talked a lot. Hopefully I answered your question.
You answered it well. Thank you very much. Thank you. You did.
All right. I have a first by Senator Weaver on the amendment. I have a second by Senator Smithman on the amendment. Comments on the amendment, Senator Gavan.
Thank you. And I appreciate your bringing the bill, and it's obviously a concern, and we've got to work on this language and protecting our children and those that can't protect themselves. I've still got to cruelly beats, golly, I was in the timeout generation. I had to go pick my own switch, and I don't know what definition of cruelly beats is, but I know some ass whippings along the way helped me get where I am today. So, there is some language in there that talks about with the intent to cause physical injury. So I think that is important, and that kind of got me over my initial concerns when I first read it. Now, the district attorney quoted some language that I do not see in here, and I don't know if that didn't make it into this or if it's maybe there's another page and I hadn't seen that, but my concern is that particularly is we're now in this amendment adding a rebuttable presumption that child abuse is concerned if the child meets any of the following criteria. The child is 5 years of age or younger, which, that one is not so concerning. The child is mentally or developmentally disabled or has been diagnosed with developmental disorder, regardless of the child's age. Well, and even with the ability unable to communicate, there's some big kids out there that are maybe emotionally conflicted or something like that. And it gets into that sort of defending yourself, restraining the child if it has to be. But we're talking about subjecting them to physical contact. Physical contact means restraining. So the way the amendment is wording, I cannot support it.
All right. Concerns on the amendment by Senator Gavan. Let's call the roll on the amendment, and we'll get back on the bill.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison,
Aye, and I'm just hoping they can work together.
Senator Elliott,
Aye.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman.
I hope that you continue to work with Senator Gavan and we tighten up on these other issues that we're talking about. But I vote at this time.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
Okay.
All right.
10 and 1.
Committee amendment has been adopted. Now we're on the bill. Any further discussion? Senator Gavan will be moved to abstain on the vote. Any other discussion? Any opposition using previous rule with the exception of Senator Gavan's move to abstention? Hearing none, bill's given favor report. Thank you, Mr. Robinson. Appreciate y'all coming down. Thank you, Senator Weaver. Let's do this. I know Senator Elliott, and we're going to try to, if y'all haven't noticed, we're way beyond an hour. We're going to keep plowing on. Senator Elliott's got some folks up here from Baldwin County. I'd like to move on to SB 157, then we're going to be on SB 121 with Senator Coleman Madison. So, Senator Elliott.
Thank you, Mr. Chairman. I appreciate it. Members, Senate Bill 157 deals with parolees and probationers. Currently, local law enforcement can only arrest a parolee or a probationer with a written statement from a parole officer. So if you have a law enforcement officer that sees somebody that knows that they're in violation of their parole conditions or their probation conditions, then they have to go back to a probation officer before arresting that individual. This bill allows local law enforcement to arrest a parolee or a probationer without a warrant if the arresting officer has personal knowledge that the parolee or probationer is violating the conditions of that probation or parole. And it further requires that the Board of Pardons and Paroles provide to ALEA the conditions of the parole so that they can see it, and then further provides that the courts provide ALEA the conditions of probation so that those local folks can see what those conditions are.
Senator Smitherman, I can see it in your eyes.
You sure do. I start out with simply, that's we just throw due process out the window. We open up that window right there. So due process, get out of here, because there again it goes back to why don't we do this? Why don't we make the requirements that and put the money out too? Now you gotta have money. That all law enforcement has to go to law school.
Mm-hmm.
I didn't even say pay at the bar. I said go to law school and finish. And we paid for it for them to go. Cause we gonna give an officer the discretion to do what the DA, what the parole board's supposed to do, and what the judge. And they ain't trained for that. There ain't been no law school. Okay. You even talking about leaving it open for hearsay. Somebody come up, some informer said, so-and-so was around the corner. They did so-and-so and so. And they gonna take that and go get him. And then a bit more, they said they have knowledge. And then first they gonna come up from a reliable informer. So now we gonna depend on the informer's testimony to go snatch somebody that they see walking around now. And say, I'm snatching you because you did this. That's why we have due process. That's why it has to go through this. So we can't eliminate due process, y'all. That's just point blank. We cannot.
No question.
When we do that, then our whole justice system is gone.
Valid concerns, Senator Smith and Senator Carol Madison.
Thank you. Senator Elliott, the question that I had when I read this bill was that, is there any way that this could be verified before they arrest the person? I mean, I understand that you're trying to do something in lieu of having to go get a written, but with technology, everything can be transferred. You know, they could take a picture of it to send it or something. So it goes back to the same thing that Senator Smithman just alluded to, of the fact that, you don't have any due process unless you're just picking up a person, oh, well, could be the wrong person.
Senator Elliott?
Well, I mean, I think, the bill clearly states you have personal knowledge, and then you have what the violation would be. Here are the conditions of parole, or here are the conditions of probation. And then you have a law enforcement officer witnessing, right, or having personal knowledge that those are being violated. Those conditions are being violated. So, I mean, there they are, watching them violate, right? And then they got to run off to go find a probation officer somewhere in order to arrest that individual for violation.
You're saying that he's in the middle of committing another crime where he's not supposed to be where he is?
The second scenario there. So this is a violation if he's got some condition from, again, probation or parole, and it's clearly stated, and that's what the requirements are here at the second part of the bill. But if you're witnessing a violation, it's clear violation of whatever the conditions are, then they can arrest them. Now, it doesn't have to, obviously, if they're in the commission of another crime, then they can already arrest them.
But again, people look like other folks, so I'm just saying,
That's what my.
Let me do this. Is there a specific reason or set of circumstances or that you could share with the committee that there's a problem that you try to fix, whether this is the right avenue or not? But
I'm going to do you one better if I can. The chief of police for Gulf Shores is right there, and I'm going to let him, if it's okay with you, come up and answer your question.
Chief, would you answer that question? I know we've got some other questions and comments as well.
Yes, sir. Thank you, Senators. Appreciate the opportunity to speak to you today about this bill. By way of introduction, my name is Ed Delmore. I've been a police officer for 41 years, the last 13 as the chief of police in Gulf Shores. So, Senators, to respond to your concern, as Senator Elliott indicated, this would be an on-view situation where an officer doesn't have information from an informant. The officer knows this individual is on probation because of the information provided through the computer system as provided by the courts and ALEA through LETS, similar to what the chief from Bay Minette spoke about earlier, having that information and access. And so let's say there's an individual in your neighborhood who is on parole and has certain rules to follow. And one of those rules is likely going to be that he is not to be hanging out or in association with another convicted felon. But we have information, valid, verifiable information about their identities and the fact that these two felons are hanging out together. And let's say that we know, because we deal with frequent flyers on a regular basis, that both of these individuals are convicted burglars. Well, it's likely that because they're together and they're on parole for a burglary, that they're going to recommit. In this case, the way it is now in Alabama, law enforcement can't act on that. They have to go through this very arduous process of contacting probation and parole. So there's no immediate ability for law enforcement to deal with that. This bill does not eliminate due process. In fact, if one were to read it closely, if there is an arrest in this case, parole and probation has 20 days to issue or not issue a warrant, and then that person who is incarcerated, just like an officer would arrest for any other violation throughout the state.
Chief, let me ask you this question regarding that. So that set of circumstances that you just gave, an officer, a pardon and parole, or probation officer, would that individual already have the right, if that's a condition of probation, to go and arrest or detain that individual for that violation that you just mentioned?
I'm sorry, I'm not sure if I understand your question. You're saying if a police officer?
No, sir. If an individual's out on probation or parole, and a condition of their probation or parole is that they not consort, hang around, be with a convicted felon, and if that probation officer knew that that event was occurring, that there were two individuals together, that was violation of whatever condition or terms of probation or parole, could that probation officer under current law go and then take that individual into custody because he or she has seen that violation take place?
Yes, sir, absolutely, they could. But one of my officers or myself could not, under current law.
All right. Senator Smithman.
There again, I see some serious equal protection problems. Serious, because I've heard a third of what I heard just clearly deals with the discretion and the opinion of that officer, and even in the statement that was made when you said that they're going, these two people together, and it's a probability that they would, I'm not saying your words, but I'm just putting what you said in my own words, the probability that they won't commit another crime. It's in the court of law, when you have a witness on the stand, they cannot testify to hearsay. They cannot testify to their mental impression. Am I wrong, lawyers? Lawyers, all y'all. Tell me if I'm wrong, so I want them folks to know I'm right when I'm saying. You cannot testify that, but yeah, we're going to depend on the mental impression of seeing two people there that we finna snatch somebody up and arrest them. That ain't right.
No, I think you're right about that, Senator Smitherman. I don't think you can arrest somebody just based on a mental intent of what you think they're going to do.
Right.
I will tell you the difference, though, I think, is that, and you used what you thought they were going to do, that's not a violation. It is the consorting with another known felon, or to put it in a different context, drinking is not illegal, right? Correct. But if that were a condition that you didn't consume alcohol while you're on probation or parole, and a probation officer or parole officer saw an individual, knowing who that individual was, having an order of the condition of probation or parole, saw that individual drinking, consuming alcohol, which is not otherwise a crime, that probation or parole officer under current law has the ability to remove that individual, detain them, and arrest them. And I think what you're suggesting is that given that same scenario, that consuming of alcohol, that if if the court notifies those conditions of pardons and of probation and parole to ALEA would have the responsibility to notify through whatever means available, let's included, so that local law enforcement officers, if they see Jim Smith out there who is drinking, otherwise not committing a crime, would not have to notify probation or parole, hey, we see this guy down here drinking. You would have the ability at the local law enforcement level to say, I see these conditions of probation or parole. I know that he is consuming alcohol. It's not otherwise a crime. I am going to now detain him the same way that a probation or parole officer is. Is that in essence, what you're saying.
That is absolutely what I'm saying. And my other example, I only expanded on my my statement there, or my example, because there's a reason why we don't want convicted felon parolees to associate with other convicted felon parolees, because often then they reoffend. So I was just providing an example of where that could possibly happen. No arrest would be made based on what we think would happen. It would be based on the fact that they are in violation of that parole.
Thank you, Senator Smith.
Mr. Chairman, my concern is simply this: is I'll stretch for what you said in my statement. Even is that if those elements exist at the time that you snatched the person, then you got that there. What you just said about the report, you said everything, but that ain't what finna happen. What finna happen? I think he did. I think he probably doing that. We gonna snatch him up. We gonna hold him. Now let's go check and get the information. No, that ain't right neither.
I would agree.
And that's what's gonna happen.
I would agree with you 100% on that.
That ain't safeguarded, that they cannot do it that way. That's what's gonna happen. That's equivalent. And I know the officers don't like, not to him, I'm talking about the officers don't like what I'm saying, but this exercise of you riding down the road and they see a car tag, so I'm just gonna run your tag to see if you did something. Come on, man, I'm fishing. That ain't nobody done nothing that you known in your presence whatsoever. It's a fishing expedition. Now, sure, they get some bites and they catch some folks fishing, but that's what this is. This is a fishing expedition to do that. And what I said earlier, I'm gonna say it again, and I said it again and again. Black folks ain't gonna get no discretion. We're not gonna get no discretion. And I'm an example of it once again. I'm in Charlotte, North Carolina, walking on the sidewalks with a couple other people. I'm up there for a conference. I ain't talking about recently. This has been about 15, 20 years ago. The officer drive up. This is what he said. He said, "Johnny, you back in town?" Talking to me.
Is that your alias?
You know? I said, "What?"
I'm gonna start calling you Johnny, Senator
Yeah,
Smith.
talking about you back in town. I said, "What you mean?" First thing he told me, "Let me see your ID." See, I'm guilty already. I got to prove I ain't guilty by proving to him that I ain't Johnny. Okay, ain't accused Johnny of no crime. He said, "Back in town." See, so I'm just saying that no, that's got to tighten up.
Senator,
got that stuff that you, at the worst, this bill, they already got it in hand.
I think,
and then they see him, and then they say, "Okay, I'm observing him, and I got right here, that he don't supposed to be talking to that person." They got to have that. Not that I know that's what somebody did. Now that's we can't have it that loose.
Senator Smithman, valid point. Senator Elliott, guardrails in place, or that you might be able to consider to address those concerns.
Thanks, Mr. Chairman. And my colleague brings up a good point, or several good points here. But if you look at line 79, I mean, the threshold is that the officer has to have personal knowledge that the parolee or probationer. But I'm happy to work with my colleague to further define what personal knowledge is.
Yeah,
I mean, I think that's perfectly reasonable to do, and I'd be happy to do that with him. And if it's okay, I'd like to go ahead and move favorable report with the understanding that I will work with him to further define personal knowledge.
First and second on favorable, and then Senator Singleton, you had some comments, sir.
I have a motion to carry this bill over to the way out, because I think it's just that important that we do that. I think the Department of Parole has some real concerns about this. They're not spoken up here today. I called over to ask, was this a problem? There's no real problem that they see, that they have with their probation officers, not being able to identify their people, know where their people are at all times, because that's their job, to know where their people are. So you're really taking it out of the hand of the parole officer this person may have just left their probation parole office, and they know about what they're doing until they warn them about something. And then the officer goes out there and make an arrest. So they don't want this out of their hands. They want to continue to keep this exclusively. So I would like to at least let's talk about this more before we move. Because I am amendment here just to leave it in the hands of probation and parole officers. That's what it is now. There's no real problem in the state. So I think we're creating a problem.
Valid points have been brought up by all. Senator Coleman Madison, did you have a comment?
No, I'll second that. I agree that that's the role of pardons and parole, and they are out there. That's what they do. So I don't understand throwing somebody else into it unless they have come together and decided, hey, we need some help. I really would like to see some collaboration with pardons and parole on this to make sure that they're on the same page.
Senator Elliott, what's your desire today?
I'd like to move the bill, Mr. Chairman, and I have gotten an appointment with Pardons and Paroles to talk about this. I talked to Director Ward, and he had wanted to have some comments, but we've not gotten an opportunity to sit down yet. But I do have an appointment with him and his staff, and I'll be happy to sit down with them, but especially with my colleague here to talk about personal knowledge and how we fix that.
I think there are valid concerns that I will stand with you, Senator Smitherman, on. If those concerns are not addressed, I appreciate your willingness to work with Senator Ward, former Senator Ward, Director Ward on that, and I would encourage that to happen. So with that, Holly, if you'll call the long roll.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott,
Aye.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton,
No bad bill.
Senator Smitherman,
No at time.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
6, 2, and 1.
All right. Bill's given favor report. Thank you, Senator Elliott. Senator Coleman Madison, SB 121.
Thank you, Mr. Chairman. You all have seen this bill now for 3 times, and we have passed it. This is the 3rd time. We have passed it twice out of the Senate. This is the voting restoration of those persons who have served their time. They're out. These are parolees. This bill has been worked on with Senator Gavan, pardons and parole. Right now, they have to apply for a certificate of eligibility. They have to understand what they owe, fines and things like this. There is no way that they can do that. Pardons and parole already keeps up with this. They have worked with us on this bill, and they have agreed to notify those persons when they have met that requirement. It also includes the requirement that they have to pay back restitution and things like that. It sets up an option for those people who are indigent. It does include community services and those kinds of things. But again, most of you all have already, I think everybody except maybe 2 people, have already seen this bill. And again, it passed the Senate bipartisan with, I think, pretty much unanimous consent. So with that, I'll move the bill unless somebody has questions. For favor.
Motion for favor by Senator Coleman Madison, second Senator Smitherman. I know Senator Gavan had a comment, and then we'll get to Senator Weaver.
So we did work on this over the past couple of years. The only change I noticed was on page 4, and I'll talk to you about that offline just to understand. That's minor in the grand scheme of things, but just want to talk to you about that later.
Okay.
Senator Weaver.
I just have a question. Have you had any conversations with the Secretary of State's office? They had talked to me earlier, and they said that they were unclear about their office responsibility in this bill.
Okay. Okay. The Secretary of State, as you know, are over boards of registrars. And the point is that they have to pardons and parole will send them a list of those persons that have completed everything to let them know that now, whatever county that person is registered in, they will let the Board of Registrars know to put their names back on the list. Of course, if the person never registered, we only talk about people who are already previously registered.
Does this automatically re-register them?
It just puts their names back on the list. No. Now, if a person never registered, they have to. It wouldn't apply to them. They've got to go through that process. Call for the question, please.
All right. If no other questions, then got a first and a second for favorable report. Any opposition using previous roll? I don't remember where we're at on that. Let's do the long roll then.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison.
Aye.
Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton,
Aye.
Senator Smitherman,
Aye.
Senator Stutz, Senator Weaver, Senator Barfoot.
All right, Bill is given a favorable report. Thank you, Senator Coleman Madison. All right, we got one more. Okay. All right. I believe I say one more. We've actually got two. Representative Shaver came in. Senator, do you mind if we give courtesy to Representative Shaver and come back to yours? Come on up, Representative Shaver.
Thank you, Mr. Chairman, members. It would have been okay if he went first. I ran. I'm out of breath. I was in another committee on another bill.
Then this is HB 272, members. I apologize.
This is the same bill that the committee passed last year. We just ran out of time at the end to get it on the floor, and we've passed it in the House 3 times, most recently this week, 94-1, and it addresses the issue that we have concerning eluding.
Thank you so much. I've got a first favorable Senator Bell, second Senator Weaver. I'm sorry, I'm getting brain dead towards the end of the agenda. I've got a question or comment, Senator Coleman.
Yeah, I just point out, it's 272. I don't have anything on 272.
Looking.
I'm looking at what I received in my packet.
This was a late edition. I apologize to the committee.
Yep. I'm not sure. Okay.
All right. No further comments or questions. I'll if you'll call the long roll for me.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison,
Aye.
Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
Okay, 7.
All right. HB 272 is given favorable report. Thank you for
Mr.
coming.
Chairman, members of the committee.
Thank you. Senator Gavan, last bill on the calendar today, I believe that is SB 149.
Thank you. So there's still some issues about probate court and original jurisdiction and will contests. While I do some probate work, I unfortunately have not had to deal with a will contest, so I've not dealt with that drama, but I see cases in Alabama Law Weekly all the time about them. I would like to do something a little out of the ordinary. The House has already passed this bill. Representative Allman passed HB 266. So if there's no objection, I would like to substitute HB 266 on the agenda and move for, I guess that's the first thing, is let's move to substitute it.
We've got a motion to substitute HB. We've got a second by Senator Carnley. Any opposition using previous rule? None heard of. All right, now we're on the amended version.
Now I'd like
substituted version.
Move favorable report on the substitute.
Senator Carnley seconds that. Any opposition used previous rule? Having heard none, it's given a favorable report. Committee members, I appreciate your ability to endure this today, an hour and 45 minutes or thereabout. Thank you. This meeting